different. The laws in the US are evolving constantly. Well, not constantly, actually, it's been few and far between sometimes, but to keep up with technological advances is the main reason for the last 2 or 3 major revisions to copyright law in the US. The most recent changes are less than a year old. I believe they were just passed in December, and we'll get back into that in a minute. No, reason number 4 where it might be confusing or there be conflicting information is that each discipline that encompasses the right of copyright when you produce something has its own particular character, and music seems to be the most elusive. You can imagine trying to explain to a federal judge the difference between this melody line and that melody line. This is not their main thing. Reason number 5, like most laws, sometimes legal precedent is set by court cases in which the judge may not have fully understood the discipline itself, or even a lot of lawyers and judges don't necessarily, if they don't deal with copyright law, they don't really have a good grasp on it, has been my experience. And there are conflicting judgments being handed down, and those are used as legal precedent in subsequent cases. And another reason, the last that I could come up with, is like most types of law that result in lawsuits, if it was perfectly clear to everyone, there would be no need for a legal opinion. So obviously there can be differences of opinion about some things about copyright. Now, there are 3 basic requirements for something to be considered to be protected by copyright law. It must be a work of authorship. It must be original, and it must be fixed in a tangible medium of expression. Now, what does original mean? Please refer to one of the previous rules about why copyright law can be confusing. All right, so we can go to my little, well, we don't necessarily have to go to my graphic, but I have, see if I can share it. I'm just a little guy. Why should I care? Okay, people say, if somebody copies my song and, I will never hear about it, and I'm only making $5 anyway. Okay. Has anybody ever heard of, oh my gosh, I want to get the title right here. Just a second. Okay. Have you ever heard of the album, The Ever Popular Tortured Artist Effect? Charlie, anybody raising their hands? No. You've heard of Todd Rundgren? Okay, a few heads nodding in agreement. Okay, somewhere in the early 80s, Todd Rundgren contractually owed a last record to Bearsville Records, and he did not want to be there anymore. So he went into his own studio. He was the engineer. He was all the vocals, all of the instruments, all of the percussion, and he wrote all the songs. It was just, did it on his iMac, right? And he put out a bunch of songs for them. And there was something that he said himself, they didn't read as didn't say to them that it was a single. And it hit 69 in the pop charts, and I think 39 in the rock charts for a minute, one of these songs. Which, let's face it, I'd love to have number 69 on the pop charts. But, and it kind of faded away. And somewhere in the mid to late 90s, some DJs on the radio started playing this particular tune, which I will tell you about in a minute, from that album, the ever popular Tortured Artist Effect. Love that title. And started playing it at the end of the day on Friday or on Friday morning. And the song was Bang on the Drum All Day. I don't want to work. I just want to bang on the drum all day. Okay, so then in 2010, almost 30 years after this minor hit for him came out, Carnival Cruise Line wanted to use this song for a national ad campaign. And in Todd Rundgren's own words, they paid him ridiculous money to do so. Okay, but you said you're not Todd Rundgren. Okay, on the list of links that you're going to get about the long tail, there is an article called About the Long Tail of Music. I don't know if everybody's familiar with that term, but I'm going to hold up a sheet of paper. Okay, here's a chart. And this would represent how much money a song makes. And this is the passage of time, right? So song is released. And however high it's going to go, it goes that high. And then it gradually falls out of favor. And then this is what's known as the long tail. Well, as you know, everything that exists on the internet exists forever. So even if you don't have as high of a peak as Todd Rundgren, you release a tune and maybe it gets a little popular for a little while, gets a little bit of attention, you're promoting it, and then it goes down. And then somebody's interested in it and starts using it maybe 10, 20 years later. And then all of a sudden, it gets in a hit movie, or a television show, or somebody uses it for their theme song and they become a big star. You don't know what's going to happen with what you put out there. And this article that is in the set of links, Charlie, if you want, you can show the links under the number one there about the long tail. You don't know when or what people are going to focus on. Another thing that could happen is there are jazz musicians who have barely been making a living since the 50s. And one of these jazz, well, he's still a pretty big star, but maybe not to you. He's not an everyday name. This guy, Bob James, there's an article about the 10 most sampled jazz artists. This article came out 7 years ago, and Bob James was sampled by hip hop and other producers 734 times. So put your stuff out there, even the things that weren't good enough to put on an album. Make good recordings of your creations and put them out there, and you don't know what's going to happen. Okay, so you do want copyright protection. You want your ISRC codes reported to places so that if something of yours, even if it's just a snippet of a mandolin introduction, somebody might use that in a Lauryn Hill album, and you are going to be owed lots of money, but you need to be able to prove, and you need, if it's in contention, you might have to go to court, which brings us to number 2, making a federal case, or what's new. Okay, this new legislation that just came up is called the CASE Act. Let's see, copyright, I don't remember what CASE stands for, sorry. One of the things that the CASE Act enables is the ability to take someone to court without spending $150,000 on legal counsel, because who can afford that? Especially if you end up being infringed on multiple times. So it's been in the works. There are still some things about it that I think aren't even settled yet, but there's going to be a tribunal of 3 copyright specialists. And at the moment, they're not calling them federal judges. And everything, I think there's even a job posting for people to take these roles. So it hasn't been put into effect just yet. Oh, thank you. Somebody just put something in the chat, but Charlie, why don't you show my links for the moment if you can?
I'm having trouble accessing that file to share in the links. There's something, so I'm working on it. It'll
Oh,
get there.
well, even just not to share the links, just to show it on the screen.
Well, yeah, give me a second. I'm trying to sort through it. It's just not working for me.
Beautiful.
I'll figure it out.
Okay. All right. So I've assembled a group of links. Some of them are from copyright.gov, which is the official, but sometimes you can't understand what they're saying. So I tried to find what seemed to me to be reputable and accurate advice based on my understanding of what I read on copyright.gov about what exactly is happening. And not everybody knows what's happening at the moment. Okay. But there is going to be a court in which you can choose to go after somebody who has infringed upon something of your authorship. And they're even struggling to make the original fee very low because the respondent has the option to opt out. They could say, I don't want you to sue me in the little court. If you're going to sue me, you have to sue me in the big court. Now, what is the reason that you're going to lose your fee? And the person might say that. Well, they might think that you're not going to do it. But there are good reasons for them to agree to be sued in the little court. And the main ones are that there are limits of $15,000 or $30,000 of how much damages you can collect. So $15,000 or $30,000, and in some cases up to, I think it's $5,000 in legal fees. That would help you out. And you don't necessarily have to hire a lawyer for this. It may be done on Zoom. You can submit documents. The rules of evidence are going to be relaxed. I can't tell you that that's the way to go, but it certainly seems a lot less expensive. Okay, another thing that is new is that they have raised the registration costs. So it will cost you a bit more money to register your works. The Copyright Office says that between 60 and 70% of their revenue was not being covered by fees. I might be getting that wrong, but so they've raised the fees to register things. And in order to sue, either in regular federal court or the new tribunal, you have to be registered before you can proceed. So it is better to be registered before you discover you're infringed upon, because you will be due what is called statutory damages. And that means that you don't have to prove that you made $15,000 less because of the infringement. It simply says, they infringed upon you, we agree with you, here's your 15 grand. So you do want to register as much as you can afford to, because you are better protected if you are registered prior to infringement, prior to discovery of infringement. Let me see. Okay, so there's links. We'll share this at the end once Charlie figures it out, but there's a link about a couple of different things in the Case Act and other news. Oh, I have to mention something else is new. And this was a total surprise to me. 2 different things are new. And I'm just going to mention them quickly. They may or may not apply to you or someone you know. if you have signed over your right of copyright. Used to be, that was it. Then I guess some really big famous people won cases saying, hey, it's not fair that I only got $750 for this huge hit. So now it can be returned to the author after, I believe it's 35 years, if you contact them 5 years in advance and say, hey, guess what? In 5 years, I'm going to ask for my copyright back. It's kind of strange that you can make a written agreement with somebody and they could pass a law and wipe it out. But I'm a little fuzzy on those details again. So you have to do your own research on these things. I am not a copyright attorney. DMCA agent registration necessary. You need to tell them who is to be notified about changes or payments. Again, there's a link, you have to read it. There's a lot of material here that I've put in links. Let's see, new fee schedule, DMC 35 return, excellent. Okay, we'll go on to the next thing. It's fair use, isn't it? There are 4 factors that a judge in court will consider if you have to go to court about these things. So you have to be, other people have to be careful not to infringe on your stuff, and you have to be careful not to infringe on other people. These 4 factors are not, you have to meet all 4 of them. It is a judgment call of, oh, well, it's 60% of number 1 and only 20% of number 2, and number 3 doesn't appeal at all, but number 4 is sort of 50-50, and the judge is going to go, yes, it's fair use. And another judge might look at the same kind of things and say, well, it's this percentages, and no, it's not fair use. So be very careful if you quote other things or if you use them. There is a list, and from NOLO, which is .com, lawyers are people who write these articles, and there's in their legal encyclopedia, there are the fair use 4 factors. Now, under fair use, something like this is an educational program. So I sang a little bit of Todd Rundgren's song, but just enough so that you would know what song it was. How much of that song did I have to sing for you to know how much it was? A judge is going to maybe look at how much did you use? That's one of the 4 factors. So, but another thing that people talk about a lot is it's a parody, when in actual fact, according to copyright law, it's not a parody. You cannot take legally someone else's melody and put hysterically funny lyrics to it about something else. Why is a parody protected, and why is doing a hysterically funny song not? Part of it has to do with our right to free speech. You're allowed to criticize things for good or bad. You can say this is excellent or this is terrible. So if you do a parody of a song, you have to hold that song up to ridicule for it to actually be a parody. I'll be happy to take questions on this later if anyone has a question about it. Okay, publication versus display. Charlie, are you able to share at least my poster? I worked so hard on it. But anyway.
Those links are up there under those Google Drive links now, so anybody can access.
Oh, okay. So it's like in the
what's
chat
up there. So which poster did you want?
Just the little pink thing. That's all right.
The little pink
so
thing?
Publication, I just had a cute picture of publication at a book, and display had the little guy, opening his raincoat.
Mhm.
And not very PC. Okay, so you might say, oh, well, this is the published work and this is not a published work. And you might actually be getting that wrong. That's number 5 down there, publication versus display. Thanks. Okay. If you have written a song and you just couldn't wait to share it and you posted it on YouTube, as the author of that song, you own, as part of your copyright, you own the right of first publication. If somebody else records that song and distributes it on their album or on iTunes or on their website, they're infringing, because posting something on Facebook is putting something on display. Think of a painter who has an art show, and you go and you look at the show, but you don't tuck one of the paintings under your arm just because you saw it and walk home with it. So I was surprised to find that some things that I have posted on my website, some things that I may have posted on Facebook, are not, according to the Copyright Office, published yet. So I still own the right of first publication. Once it is published, once I have recorded and distributed, then it is published. Okay, right. So let's see. 6, register. How? All right. There are 3 different ways that you can. I know songwriters who write 2 songs a day, and I know songwriters who write 2 songs a year. Okay, but sometimes you have a bunch of stuff and you want to protect it. There are 3 different terms used in copyright registration, and they have very different meanings. And if you try to register it the wrong way, the Copyright Office will send it back to you turned down, and you'll have lost your fee. You'll have to register it again. So there are 3 different things. One is collective work, the other is group registration, and the third is unit of publication. Okay, just all right. So I'm going to get rid of collective work, because unless you're a record label, it is highly unlikely, or unless you're putting out your own greatest hits album, is highly unlikely that you will ever put out a collective work. If when you were in junior high school and the teacher passed out soft cover collection of short stories from the first quarter of the 19th century, okay, that is a collection, and the individual stories are by different authors. The person who put out this collection can copyright the fact that they have curated these particular stories in this particular order, in this kind of a volume, with this kind of text. That is a collective work. You are not getting a copyright on the underlying works that make up the collective work. An example would be somebody puts out the greatest hits of produced by Berry Gordy. They would have to get permission for every single song they put on there, and they could copyright the fact that they put these greatest hits together and the package and all that kind of thing, but they would not be getting any copyright on the works contained within. So you do not want to do a collective work. You probably want to do, to save money, and you can always do everything individually, but to save money, there are 2 things. One is a group registration, and the other is unit of publication. Now, the one you're going to be most familiar with, the one you're going to be most familiar with is you put out a CD. And if you wrote every single song, all the music, all the lyrics, all of the artwork, all of the text, all of the graphics, if it is a complete package of original work that you should have the copyright, you can put your entire album copyrighted both the underlying works and the packaging of it together in unit of publication. That will include the musical works and the sound recording, the cover art, the graphics, the liner notes, and posters. However, if there is even one thing on there that is not original to you, if you did not create it and you do not own the copyright to it, you want to do 2 different group registrations. You can register up to 10 original musical works or up to 20 unpublished musical works or sound recordings, and up to 20 sound recordings. I know that sounds confusing. I don't know if you're taking notes, but sound recordings, group registration, up to 20 of them, just the recording. The underlying musical work, up to 10 of them. But if everything is unpublished, completely original, you can do up to 20 unpublished musical works and sound recordings. Now, should you quote me on this? No, you should go to the copyright.gov and double check every bit of information, but I believe that that is correct. All right, number 8, work for hire. All right, which I called on the poster, please release you. What is a work for hire? Now see, the number 7 is running away from the work for hire. Okay. It is not standard practice. I know that, but I highly recommend that you get a release, a signed release from every single person who has contributed anything on any albums or recordings that you release. You should get a release from your bass player. You should get a release from the person who designed your disc. You should get a release from the audio engineer. Anybody that has done work on it. It can protect you down the road from somebody taking what little money you may, or great amounts of money that you may make from the work that you own. If you have it in writing, a work for hire may or may not protect you. A work for hire, if you, in its strictest sense, only covers 8 types of work. For example, a sculpture. I am not 100% positive. You might have to consult with someone else. A work for hire should technically help you. For example, photographer takes publicity photos for you, for example. But if you don't get a work for hire, or if a work for hire doesn't apply, get a release. Get somebody to sign something. Pay the people who do stuff for you, pay them well, and say, look, I want to be able to pay you well, but I need to own outright what you are contributing. Right? There's a court case where somebody played a cool organ riff on a tune they did not write. And, 20 years later, somebody owed them, $70 million. If you're lucky enough to have a huge hit, I wish you a huge hit as big as that, and maybe you'd be interested in sharing some of your money. But it helps you if you have a signed document. All right, joint authorship and derivative work. On number 8, I said we're going to go through it together. Okay. Technically, according to copyright, a joint work is a work that 2 people contributed to and would not exist one without the other. So in its strictest sense, Oscar Hammerstein II wrote lyrics, and they were 3 separate pieces of poetry, and he sent them to Richard Rodgers, who wrote the music to them, and they wrote these great shows and have these hit songs. a copyright judge might say that's not really a work of joint authorship. So once again, a piece of paper about what your agreement is before you work together would be terrific. However, a derivative work where somebody takes something that you wrote and does something to it to change it into something else. They take your song and they turn it into a short story. You take somebody's short story and you turn it into a movie. Is it derivative or is it transformative? I have some links for you to read about that, because you have to be careful about using other people's work or when other people use yours. Oh my gosh, we're technically already out of time. Let's see, what was the last thing is, Charlie, thank you for the poster, Charlie. I worked so hard. By the way, I don't know if you can see me, but the any resemblance to the little figure in the hat and me wearing a hat today is purely due to my poor penmanship. All right, so I have also a checklist for non-infringement, and it is a worrywarts checklist to go through where you can look at something before you release it and make absolutely sure that you are not infringing knowingly or unknowingly on someone else's work. Charlie, are you able to get that one up there? In the meantime, do you want to open it up for questions? Questions? Anybody?
I would
Questions?
love to open it up for questions. Which one am I going to share? Although, in order
the checklist for non-infringement.
the checklist.
What'd you say? Oh, he shared.
It is shared in the chat.
Oh, I got to look at the chat.
You do, but we can.
Oh, I see what you mean when you said you put a Google Drive thing. Excellent.
Yeah, but
will these be available after this talk is over and people are watching this?
Everybody's able to share the chat or save the chat. So,
fantastic. Yes. Would you share the chat? I mean, save the chat?
Yeah, yes.
MT? Thanks. Excellent.
And then if you look at your screen, we have that.
Works on the same application. Thank you, Brant. See, copyright.gov. Now, it says Circular 34, Brant Miller. So we have to find out if that is, I guess if it's on their website, it's supposed to be updated. Okay, 10 unpublished works. Musical works, up to 10, yes. That's funny. When I looked it up, it said unpublished. It could be 20 musical works and sound recordings if they're all unpublished. But all right, well, I will defer to the copyright.gov website as your Bible here. So if I've given information that's a little bit out, you really have to do your own checking into things to check onto them. But I hope this was helpful. I'm still waiting I didn't hear a single question yet.
Well, if people want to put up their hands, and I see Brant's little yellow hand up, that will help us to figure out who to ask. So let's begin with Brant. And you appear to be unmuted, but we're not hearing any audio. And I don't see anything on my side that would change that.
Maybe you could call us.
Yeah, if you could just type it into the chat, then we can. I'll just read it off.
Sorry, Brent. I was dying to hear what you had to say.
Oh, I think I heard a sliver of sound for a moment. No, I'm not hearing anything. Yeah, I'm not sure where we can get that. Yeah, if you could type your question in, Brent, or are you making a statement or asking a question, I guess? Yeah, we're not getting any audio from you. Well, let's jump to Inanna, and then we'll come right back to you if hopefully you can figure out.
Excellent.
So Inanna, did I pronounce it correctly?
Yep. Can you hear me?
I can hear you.
Okay, great. So I've never done any of this before, and I'm just wondering the best way to copyright songs that I'm not going to make an album out of. I just want to sort of get a basic protection so I can put them online, like on YouTube. So can I register 20 songs at once and then subsequently put them maybe on different albums if I chose to later? And would I have to re-register them at that point?
Okay, so Inanna, fantastic question. According to Brant, my number might be off. I thought it was up to 20 unpublished, and he said it looks like it's up to 10 unpublished. But remember that if you record songs, there are two separate copyrights in play. One is for the musical work. Are these original songs?
Okay.
Right? And Anna, these are original.
Oh, yes, they are original.
10 or 20 original songs.
Right.
Right? Okay. And then you have the sound recording. So what you want is a group registration. And in the group registration, if they are unpublished, you will, oh, fantastic question, Carol. Sorry, I got distracted. In the group registration form, it will tell you how many and what you are protecting. Think of MW is for musical work, SR is for sound recording. Now, if you just want to copyright the musical work and later you're going to put out a sound recording, maybe you don't have to copyright the sound recordings that are just your working demos right now. But if you are able to combine that, but I would really recommend you go to the website. Hold on one second. Your camera seems to... So it has.
I'm pretty sure Brant's audio is back on. So
oh, can yeah, I was just
right after. Oh no, let Diane finish
yeah,
answering. I just want to let you know that you'll be next.
No, I think Inanna, does that answer your question?
Yeah, so you're not copywriting both the musical work and the recording with the group registration. You have to do them separately.
I would say go to the
okay.
But you definitely want a group registration.
Okay.
Whether it's an MW or an SR or whether you can combine it, I'm going to leave that for you to look up that detail because I don't want to be wrong.
All right. Thank you.
Thank you.
Okay. Well, let's jump over to Brant.
Go ahead.
Okay, I'm not sure what's happening with my. I put some new speakers into to my laptop, so I think things got kind of moved around. Anyway,
you're loud and clear now.
First of all, that information about that tribunal was interesting because I'd not heard about that. I've not really been in the loop of what's new in developments, but so that's going to make it better for the writer to be able to get some compensation, apparently.
The goal of it was that they recognized because of the high cost of protecting works and people who write, songs and magazine articles or blog posts or something like that, where they're really not making millions of dollars, they called it a right without a remedy, because the high bar of the cost of it is literally, if you are protecting, going after someone who infringed on your copyright, it literally is a federal case. When people say, don't make a federal case out of it, this is a federal case. So they recognized that for many years, people were not able to protect themselves against infringers or go after them because it was such a high bar of cost. So what they did was it took many years, and then it happened during the pandemic. It actually got folded into one of the appropriations bills in December. Oh. So it got folded in with the appropriations bills to have this lower cost venue. It's not in play yet. The original deadline, I believe, is the end of December, but it can be an extra 6 months. I don't know exactly how long it's going to take for them to set it up.
Okay.
The whole
Now,
idea of it is it doesn't cost you so much to go after a small infringer if you're a
right.
little guy.
Well, if it's a big infringer, let's say somebody has a huge hit on it, and you can prove that they stole something. There have been cases like George Harrison for "My Sweet Lord," and
Definitely with the, yeah,
and having to you pay a lot of money. Is that going to still be a recourse for that if someone really
exactly.
goes to the bank?
It is optional on both parties. It is your option to go after the infringer in whichever court you decide, but the little court, the infringer can say, no, I opt out. And then you will have to go to the bigger court to pursue it. If you believe there is a lot of money at stake, find a really good lawyer who will take it, who will see the big money and go to the big court.
Yeah.
But it can cost $150,000 just in lawyers' fees to pursue federal court.
You got to be sure you want to go that route. Okay, and I did have another question, if I can ask about I've done the multiple works because it used to be copyright was $35, probably less than that at one point, $20, but now it's like what, 75, or for either one song or for 10 songs. So certainly I like to do at least several songs if I feel like want to protect them when I'm starting to play them out and stuff. But as far as once you have an album out, I kind of was under the impression that they really would like you to publish the songs, each song in that album as a published work versus an unpublished work, which would be like $75 or whatever it is per song, which I haven't done for my recent CD because it's going to get really expensive. I put them together, I think, as one compilation of, not compilation, but group copyright. And so I'm wondering, you may not be able to answer this right now, but I'm wondering that if it had to go to court, if the unpublished copyright would protect your song after you've released it as in an album.
I have two things to say. One, I just want to get out of the way. If when you put out the album, again, if everything on the album, including the artwork, you can say that you own the copyright to, and you're not doing any cover songs or anything like that, the unit of publication covers the CD as a physical product, the sound recordings, and the underlying musical works. But if you have copyrighted an unpublished work and later you publish it, it's still copyrighted. It's just you copyrighted it while it was unpublished.
Yeah, I just, they
Does that help you?
Yeah, they kind of tell you that you should do that, and
Who's
it's kind of
they?
like Copyright Office in their description of the copyrights and the different types. I've interpreted that as being, you also have to. I know I've also done copyright of the whole album before, and I wasn't sure if that included the actual each song as an individual song, or if it was just for the whole CD that included those songs. And so that's something I was unsure of.
Just a second. Well, I'm not sure how that applies. Sorry, I'm getting another note here. If you have something registered and it's properly registered, the musical work is registered properly, then you are able to go after someone in court if you wish. Does that help?
Yeah.
Okay.
I feel like it would be sufficient, but
I'm not sure who you spoke to at the Copyright Office, and I'm, again, sound recordings and underlying musical works. two separate things that both separately, yes, all the musical works need to be registered. All the sound recordings need to be registered. You can write a song and somebody make another recording of it. You have your copyright of that song. You have your sound recording, and somebody could say, wow, I like that triangle he's using there. I'm going to take that out and use it. You understand? So when they say separately, I don't think they mean individual songs. I think they mean that I wasn't in there when you were speaking to the Copyright Office, and I don't want to refute anything that they have.
I was just reading it. I think I was just reading it. That's what it may have, that's what I interpreted.
You want to copyright both the musical work and the sound recording if you release something. You want to make sure that they are both registered. It's not a must, but it will help you pursue any issues down the road. You cannot file a court case until not only after you've applied, but you might be waiting 6 months for your registration certificate to come in the mail. You cannot pursue a lawsuit until it's registered. So two separate, when they say individual, they say, I think they're talking about, not individual, but they say separate, the musical work and the sound recording. Okay.
I appreciate it. I'll let somebody else.
Yeah, let's
and
jump
I like
to another.
Matthew's comment there, his visual comment of, they need fees too. It's true. Okay. So I would like to address some.
I was going to jump to Carol's question, and if I could rephrase this for you, Diane, just to see if we can make it make sense within this conversation. So Carol asks, is anyone on the call familiar with copyright law as it relates to festivals, both in person and virtual? Now, I'm kind of wondering if this has more to do with performing rights organizations.
Can we hear her voice?
Carol, can you ask us? Where did you go? There you are.
Hi.
Hey, yeah.
Hi. Yes. So, that's the question. That's the simplest way I can put it, is how the copyright law relates to festivals as opposed to performers, and how it differs when you're doing a live festival versus a virtual one.
Okay. Well, if you're creating artwork for a poster to advertise your festival, that is a copyrightable work unless it was done under a work for hire agreement specifically prior to that. But in terms of you presenting people who are performing live,
right,
that is not so much a matter of you claiming ownership of the songs as a performing rights organization such as ASCAP.
Right. Yes, that's what I'm talking about. I'm specifically talking about ASCAP, BMI, and the PROs.
Okay.
Yes. So I thought you were. I'm sorry, I misunderstood if that was not part of this afternoon's conversation.
I wasn't meaning to address that, but I imagine anybody who is presenting music, and this is, believe it or not, even true if you get a jazz gig. I get a jazz gig at a restaurant, and supposedly I'm supposed to ask the restaurant, well, are you paying ASCAP, BMI, or CSAC? Even if they play the radio, they're supposed to pay a fee. And those fees, I'm not that familiar with how they collect those, but I will be at some point because I'm hoping to also be a presenter. So I can tell you a little thing that I have heard, and that is if performers are collecting money which is deemed direct contributions from the audience, as opposed to you selling tickets, which probably does not apply to you. But if you are taking a donation that you don't touch and doesn't pass through your bank account or anything, and it's asked for but not demanded of the audience, and it goes directly to the performer, I believe that you can sign on to ASCAP and BMI as at the lowest priced amount, because you are not doing X number of hundreds of thousands of dollars of business a year. But I'm afraid I'm not really versed in that subject.
Okay, thanks.
I guess what I should have said was, I don't know.
I
I'm
think
sorry. I want so much to be helpful.
I think what Joel, or as some of you might recognize him as Matthew today, was saying.
Why I didn't recognize Joel.
I don't know if it's middle name or somebody else's name within the family. I don't know. But anyway, Joel makes a point about an old copyright of an unpublished work that gets published is covered from the date of creation and only certified by the copyright. And I'm wondering if this goes back to the old method that we took in the 90s, which was take that 4-track cassette, stick it in an envelope, get it stamped by the post office, and you're set. Is there any legitimacy to that? Does it work?
I just want to bet, Charlie. I bet my colleague here that somebody was going to bring that up.
And I'm asking the question, I guess, that based on Joel's thought there. So what is the truth on the old mail yourself a cassette?
If you sit in your living room and you're sitting with your guitar and you have figured out a new song and you've got it up here, it's not copyrightable yet. Believe it or not, it has to be fixed in some sort of medium. So yes, a cassette tape, or making a painting on a piece of board, or typing a story on a computer is a fixed thing that somebody else can, or writing out, remember music notes, writing out the music notes of your song on a piece of paper. At that point, your ideas are not copyrightable, or are they? Ideas, you can't copyright an idea.
That would be a patent.
But once it's in some sort of fixed form, you have a creation, a work of authorship. By the way, it's very interesting, this authorship idea. There was a nature photographer who left a camera out for a chimpanzee or something to play with. And the chimpanzee took a bunch of pictures. Nobody owns the copyright to those, not even the photographer who put the camera out there, because a monkey cannot own a copyright.
Why not?
Because it's the law.
Can AI?
It's not a work of authorship.
It'll be interesting to see how that conflicts with AI in the future as that starts to create
Exactly.
its own.
Well, this is actually in debate right now. Can a computer be an author? They're writing music, they're writing code, they're doing all sorts of things, but right now they're not considered parties to any law, because laws don't apply to dogs, monkeys, computers, as people. Mm-hmm. So it's going to be interesting. Again, the copyright law always seems to be 20 or 30 light years behind technological advancements. So okay, let's go back.
Let's ask Brenda a question. She is asking.
My
she
songs are copyrighted.
Are those songs protected? So she says, I have all my recorded songs copyrighted individually, and the albums as a whole have been copyrighted. I have some new original songs posted on Facebook and on YouTube. Are those songs protected at all?
Okay, so you put them on YouTube, and there is somewhere a video of you performing them. Therefore, they are fixed. So it is copyrightable. You own the copyright. You have the right of first publication. You own that song that you created, or the co-write, the two of you and you should have a written agreement. How much of the, do you share every 50-50 of the music and the lyrics, however. But yes, once it is fixed and you have displayed it, but you have not published it, so nobody else is allowed to record that song without your permission. You have fixed it and you have displayed it, but you have not published it. Publishing is an act of
Commerce?
No, not so much commerce. It's
YouTube would not be publishing?
YouTube is not publishing, it's display.
Okay.
When I sell you a copy of it is when it's published.
Okay.
Okay, we have a bunch of questions. You are just trying to document when the work was going. Okay. Joel, sorry, I called you Matthew before when you were going like this because it said Matthew, but I remember you now when you said Joel. Okay, it gets published. That's right. That's what we're saying. The date of creation and fixing. If you haven't fixed it in some tangible form, record a voice memo on your iPhone. It's fixed. At that point, the underlying work that you made a recording of is fixed, and it is a work of authorship, it's original, and it's fixed. Those are the
so to break that down, so I have a fixed recording of this song. I threw it on Bandcamp for a minute, didn't go through the Copyright Office, and Katy Perry steals my song and makes $1 zillion. I don't know who the popular artists are today, so that was the first one that came to mind. I don't think she's going to steal my music, but who knows? You never know.
Wouldn't recognize it if she did, possibly.
Whoa. Yeah. So she steals. She uses my song, and the only thing I have it on is the digital voice memo that I have in my hand.
Mm-hmm.
Then I can take that fixed version, certify it through the Copyright Office, and then go forward to sue her?
You must register it.
Okay.
Then you can sue her. Now, in the meantime, her record label has already registered that. So then you either get a settlement or you get to go to court. What was her name? Ariana Grande, was that? Mm-hmm. Ariana Grande? She wrote a song that was My Favorite Things by Rodgers and Hammerstein. These two names are always coming up in my life. And it goes da 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 da, like, and in between there's like a little riffing that she does, and she changed the words and made a cute video. So her record label went to the Rodgers and Hammerstein Foundation, or whoever it is, whatever organization they have to deal with. And Rodgers and Hammerstein heirs and I'm sure it's a very imposing office of whoever owns all the rights to these songs, could have said, sorry, can't release it. But they didn't. They said, give us 90% of all the money. And so she gets 10. Do we have more questions in the chat? I'm sorry, I wasn't reading it religiously before. I was too busy talking.
I'm not necessarily seeing any
group
questions.
Registration up to 20. See, group registration, Brand, up to 20 musical works or 20 sound recordings containing an album if the works are by the same author, at least one common author.
Brant, is your hand currently up on purpose, or is that just not a
leftover?
Just leftover.
Okay.
But I will say that I just did Google there, and it does have 20, but that's for an album. So that, I guess that is a
no. I'm sorry, may I just, okay, it says up to 20 musical works, right? The MW, or up to 20 sound recordings, the SR, contained in an album, it doesn't mean necessarily an album that you are publishing. Okay, if you want to do a record album and you own everything, you want a unit of publication, because that protects the sound recordings, the musical works, and all of the graphic blandishments, or whatever you would call, the cover art, everything. As long as you own and control the copyright to every part of that, of your CD, a unit of publication will do not or, but and 20 musical, I don't know if it's 20.
Well, it says on the copyright site, and this is something new that was actually a rule from February of 2021. Under this option, an applicant may register up to 20 musical works or 20 sound recordings contained in an album. Oh, you're saying or 20 musical works, or
it says
okay.
Or. I'm confused why
I'm
it says
confused.
group registration, because unit of publication changes that to an and. See, it says in the case of an application to register sound recordings, the applicant may also register literary, pictorial, and graphic works. I am distinguishing a group registration MW or a group registration SR from a unit of publication, which is, if everything's yours, you can get it all together. So I don't know where you're looking, but where you're looking is not the law. It might be the FAQs, and the FAQs might need a little tweaking.
I put the link there. It's the copyright.gov rulemaking, and it says establish the new group registration option for musical works, sound recordings, and associated literary, pictorial, and graphic works contained on an album. It does mention an album. This is known as group registration for works on an album of music, or a GRAM. And so that link there, I kind of did it right after the first thing I posted. It has,
okay.
That's where I'm looking at, and it has information. Sounds like it may be an album as opposed to 10 works. If you just have a bunch of different songs that you want to copyright at one time, that would be a different thing maybe. But I guess we have to kind of look into that more to make sure that we're
okay. But you see underneath it says 2 new electronic applications. So there's 2 separate ones. One is for the musical works and one is for the sound recording. And it does look like with the sound recordings, if it's an album, it can include the pictorial and graphic works. But once you register the sound recordings under group registration, you have not registered the musical works. And that's really where the money is, we hope. Do you understand what I'm saying? I just opened up your link, and underneath what you quoted, it says the office is providing 2 new electronic applications. And that's what I'm saying. One is for the musical works and one is for the sound recording.
okay, for musical works or sound recordings as appropriate.
Or sound recording. If everything's original, wouldn't you rather do the musical works and the sound recording?
Yeah, if that can be done for an album, I guess you got to study.
Let me put it this way.
Yeah.
I put out an album of cover songs. I do a group registration for sound recording, and it will include all of my sound recordings and the pictures and the liner notes and the cover art. It doesn't cover the musical works contained within the sound recording. A unit of publication, if everything is yours, you can do a unit of publication, which is better than a group registration of just the sound recordings, because it also includes the musical works. We can talk later, Brent.
Yeah, it's a little
maybe
confusing.
I'm not being clear.
No,
a curious thought in my mind. So what you're saying, so if I released a record of popular songs, the sound recording copyright would apply to the actual audio. So if somebody used me singing Take the A Train.
Take the A Train. Beautiful.
if they recorded, or if they used my version of Take the A Train in a commercial, I would hold the copyright for that audio recording, but not for the song.
Exactly.
Okay.
Does that help, Brent? Oh, you're
You
muted.
just went quiet again.
He's muted.
I'm going to study
there you
it
go.
more. I'm going to study it more so I can kind of absorb it into my thick skull a little better.
Do you
Because
remember what I said at the beginning when I said it takes a certain kind of mind to grasp esoteric nature of copyright? It's also a lot of legal gobbledygook.
yeah, it's a lot of and, or, and buts. So anyway, we're kind of narrowing it down now to at least muddy.
Yeah, legal speak, I'm never quite sure if it's written that way to keep the rest of us confused, or to make sure that it's thoroughly clarified. It might be a little bit of both.
Okay, were there more questions in the chat?
I didn't see any more.
I saw comments. Let's take a look.
Last thing I saw was Brenda saying she has to go, and Joel saying he has to go. But that's it. And there is one hand up.
Anybody who didn't have to leave?
Steve has his hand up.
Go ahead.
Where is Steve? Oh, you're in the corner. There you are. And you are muted. There you go.
Can you hear me?
Now we can.
Oh, okay. How about now?
Yep.
Okay. I just want to, first of all, thanks for this. It's always been a mystery to me to copyright music, but I want to thank Brant for giving me a great idea for song title.
Really?
And, or, and buts.
Go for it.
All right. I'll share the revenue with you.
Well, he can't copyright an idea.
No, you can't copyright an idea. If we did that, then there'd be a million co-writers
right.
around the world.
When I write and record the song, I'll give you half.
Just dedicate it to me on the CD. Just saying, and to Farm too. Farm needs to get some plugs.
Yeah, there you go. Yeah,
there we go.
I just got one more question. Is it and, or, and buts, B-U-T-S or B-U-T-T-S?
B-U-T-T-Z?
Z, yeah. Anyway, thank you again. I'll put my hand down.
Thanks. And there's Make Lawyers Rich, says Mark Smith. Well, I don't see any more questions. So thank you, Diane. You've done great. If you want to stick around when we're done, we'll wrap up.
I do want to quickly go through my crazy non-infringement checklist. Okay. This is the Worry Warts version. Okay. This is if you are the Felix Unger of you will stay up all night worrying if you don't own absolutely everything on your album. Like I said, you can pinch and squeeze this thing probably to close it. Okay, there we go. All right.
Control plus and minus and on the desktop.
If you want no possibility of infringing on another's work, use this rule of thumb. If you did not create it, don't use it. Okay, for CDs and other products, go through each song before you release. Did you compose the music? Did you write the music? Did you write the lyrics? Ask your producer or your engineers. Did you that cowbell that you added? Did you actually play that on a synth, or did you get a sample of somebody else's song where you really like this groove? Where did you get this riff? Samples in production, of course, are much more prevalent in a couple of other genres, which shall remain nameless. but they can show up. An engineer might say, "Oh man, here's this bass part," and he doesn't even realize he actually grabbed a section of somebody else's song because he doesn't even know where it came from. He or she, excuse me. Okay. So ask them and ask them to write a thing where they are telling you. Oh, and by the way, I know I don't really have to say this in this group of colleagues, but should anybody fall upon this talk, just because it's on the internet, you found it on the internet, doesn't mean you can use it for free. You can't. It belongs to somebody. Okay, scroll down. We got All right, so that's for the musical works. Then for graphics, illustrations, decorative borders, and backgrounds. Where did they come from? Even fonts. I got to tell you, you can purchase the right to use a font privately and download it onto your computer. And then use that font on your album. That is not private use. Okay, so where did that font come from that looked so cool that you used? Did you pay for the right to use that font? People actually sit around designing fonts. Okay, other aspects of the design, such as typesetting. Okay, photographs. All right, this might sound a little crazy. Besides getting a release from the photographer to use the publicity photo, you may have paid them, right, to get a release to use it for anything you want in perpetuity, and give them credit. They were still the artist who took that photograph, whether you like the rest of their work or not. But look, is there any artwork in the background? Are you standing in front of the Mona Lisa? Well, the Mona Lisa is actually public domain now. And that's why you see so many jokes about it. But also, are you wearing a t-shirt with a design in it? You don't own the design on your t-shirt. You can buy a t-shirt. You don't own the design of it. The cover art, is it original work? Oh, and now I will show you. Well, now I can't show you because we're sharing the screen, but on my jazz CD, Out of My Dreams, I made the artwork. But guess what? I still needed a photographer to photograph the artwork for me. So they gave me permission to use it in perpetuity for anything I wanted. Posters, cover art, in future generations, there might be a form of giving people music that's not on a CD. If I just got a release to use it on my CD, not only that, if you're using it on your CD and then your songs are also available for download, when people download your album, they're getting that artwork. So you have to make sure that you have permission to use that photographer's work for those purposes. And you have to make sure you have the right to use that cover art for those purposes. And here's posters, t-shirts, other physical merchandise. And is there more? Dun, dun, dun. Text. Okay. Liner notes. Who wrote the liner notes? Did you copy something out of a magazine about such and such a composer? Other people's lyrics. Guess what? You may have paid for the right to record that cover song. But if you did not separately get permission to print those lyrics in your booklet, you have infringed on the lyricist's copyright. And if it's a really famous song and that person is wealthy, why shouldn't their people get in touch with your people? Quotes. This sounds a little crazy, I know, but if somebody gives you a quote, ask them for permission to use it to promote yourself and leave it very open-ended. Credit songwriters on product, okay? If you do a cover song, you are supposed to list on the packaging. And I know this is, so 20th century of me, packaging for music, but you are supposed to list the songwriters and add your own copyright notice. That's not really to prevent you from infringing on other people, but, put it out there. There's a million different ways of doing it. Find one that you like. Okay. And we're only 22 minutes over.
We're not really over. I have one real quick question on text. Is there a fair use within text? So say, well, you said lay, lady, lay. So if I use the line, lay across my big brass bed, is that fair use or is that copyright infringement?
Where are you putting those words?
I don't know, maybe in a description of Bob Dylan on my website.
Okay. Remember when I said there are 4 factors and the judge is one of the factors is how much of it did you use?
Mm-hmm.
Use more of it than you really needed to make your point.
Okay.
Now, who's going to judge how much you have to use to make your point? And what is the point you're making? It's kind of up to, so yeah, generally short snippets are okay as long as you don't use any more than you need to make your point. In an educational context, even in an educational context. I can't take an entire textbook and photocopy it and hand it out to students.
Mm-hmm.
That would be infringing, even though I'm using it in an educational context.
So we just have
does
to
that
hope
answer
that
your question, that there is no answer?
Yes, because the judge could have been the name that tune champion who was always able to nail it in one note.
Okay. Well, before we go, I do want to say that I am very grateful to have had an opportunity to repay Folk Alliance Region Midwest for all of the wonderful things that they always do, but especially how they leapt into the fray. Actually, there was no fray. You guys leapt first out of all of the regional and even the international organization. You guys started getting us just talking to each other about what we were going through and offering tech talks and companionship and being there for us. And I am just so grateful to have some way of, in my small way of trying to repay that. So thank you so much for the opportunity.
Thank you for being a part of this for the past year and a half and today. So thank you very much, Diane.
And thanks to everybody who showed up. I appreciate it.
And we would be nothing without the energy of our of Annie Caps, honestly. So as we sign out today, if people could turn on their cameras, that might be Annie behind that one. It could be Brianna, it could be Karen, I'm not sure. But if we could turn on our cameras and just say, "Hey, happy birthday, Annie," maybe she'll see it later.
You're still screen sharing, so we can't turn off our cameras.
Okay, let's do that. I can't really see that.
Here's my artwork.
There we go. It was Karen. Okay. I wondered who was behind that.
I just want to show my artwork. See, I made my own artwork.
That's great.
And this is my new one, and I made that artwork too with the help of the engineer.
Thank you so much, Diane. So let's all, in our normal wave, give a wave and say, "Hey, happy birthday, Annie."
Happy birthday,
Annie.
Happy birthday to you. To you. We don't have to pay for that one anymore, or do we?
We'll make up our own little banjo birthday time. Cool. Well, thank you all. And hey, tomorrow evening, let me make sure that I get the deets correct. I don't know if the kids still use that word. I think that was popular in the 80s or something. Deets, details, farm folk. So tomorrow evening, I believe we are doing a venue upcoming events. We are doing a venue peer session.
What time?
Live. It's the live music presenter peer gathering. It is 8 p.m. Eastern, 7 p.m. for those of you in the Central Time, and do the math going all the way to right back around to Nova Scotia or wherever that changes again. And then Thursday afternoon at 2 p.m. we have our emotional support peer gathering, and those have been great. They're usually smaller groups, and they're really about just checking in with each other, because every once in a while we all need that. That's this Thursday.
At what time?
At 2 p.m. Eastern.
Okay, great.
2
Brant,
p.m. in
I
New
just want to
Jersey.
say, Brant, if you want to continue our discussion, you can shoot me an email or with your phone number.
Okay, do I have your email, or do you?
Oh, let me put it in the chat.
Yeah,
Okay.
thank you.
That's a good idea for anybody
Thank
who wants
you,
it.
Diane, appreciate that.
And just to make sure everybody is fully aware, because we are currently in the process of getting our website updated with the big upcoming registration and everything that's going on. We are not doing an in-person conference in 2021. That has been postponed again till 2022. We will be in Lisle, Illinois in 2022, which is near Naperville and Two-Way Street and all those great coffee stages that we have in that area. So we will be doing a virtual conference Halloween weekend, but not on Halloween. So keep that in mind and keep an eye on the website for when registration begins, because it will begin very, 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 very soon. And we will explain all the showcasing and anything else that we are going to present on the website to keep that in mind. And I think that's all we have today. So thank you all very much for joining us today, and we will sign off. I'll be the last one to go, and Diane and I'll probably talk for a second.
Excellent.
So thanks.
Right.
I hope it helped and didn't confuse you more.
And go ahead and turn off the recording. Recording is stopped.
Oh, stop in the name.